May it please the court. They saw and they kept serving. It's March 24th, 2019. Jessica Marks and her friend Morgan Levin are out for a night of drinking. Both are underage. After having a glass of wine at Jessica's place, they drive to Sunny's rooftop bar where they know they won't be carded. Once inside, they head for the rooftop and order the first of several rounds of drinks. It is during the course of the evening that Jessica will consume a bottle of wine, beer, hard seltzers, a mixed drink, and a shot. As the evening progresses, her speech becomes slurred, her voice becomes loud, and she even falls. But Sunny's keeps serving her anyway. Shortly before midnight, Jessica leaves the bar, gets in her car, and less than a mile from Sunny's, drives off the road into a ravine and dies. At the time of her death, her blood alcohol content was 0.16, well above the legal limit. They saw and they kept serving. Good afternoon, ladies and gentlemen. My name is Sophia Cho, representing Ethel Marks, the mother of Jessica Marks. I'm here today because Sunny's had a duty to stop serving Jessica once she became obviously intoxicated. It's the law in California. It's called the Dram Shop Act, and it requires bars to stop serving obviously intoxicated minors like Jessica. If they don't, they're liable for the harm that results. In this case, they're liable for Jessica's death. Now, as the plaintiff, we bear the burden of proof. We have to prove to you that it's more likely than not that Sunny's failure to stop serving alcohol to Jessica after she was obviously intoxicated caused her death. Now, you're going to hear from Morgan Levin, Jessica's best friend. She's going to describe to you just how much Jessica drank, to the point where Morgan didn't feel comfortable driving home with her. But more than that, how Jessica was behaving and how Sunny saw it, but kept serving. But don't just take Morgan's word for it, because we're going to show you a video of Jessica taken that night. After that video, you're going to have no doubt of Jessica's intoxication, the intoxication a reasonable person in Sunny's position should have clearly seen. Now, the defendant is also going to testify, the owner of Sunny's. He's going to admit to you that he had numerous interactions with Jessica that evening, 8 to 10 to be exact, and that he served her alcohol right up until closing. They saw and they kept serving. Because of that, we're going to ask that you hold them liable for Jessica's death. Thank you.
Thank you, counsel. Opening statements from the defense.
Yes, Your Honor. Members of the jury, today you're going to hear a story about two students. On March 24th of 2019, they both went to a bar, ordered a number of drinks, and by the end of the night, well, neither really should have been driving. One student, Jessica Marks, died. But the other student made it home. The difference? The choices they made along the way. Now, when the plaintiff brought a claim of wrongful death, they took on a burden of proof. Today, they have to prove two things by a preponderance of the evidence, or that each is more likely true than not true. First, they have to prove that Sunny's bar kept serving Ms. Marks when she was obviously intoxicated. And second, that as a result, she died. But members of the jury, well, even if the plaintiff meets that burden today, that doesn't mean that Sunny's bar is liable. Because today we've brought an affirmative defense of comparative fault, All that means is today we're going to ask you to compare the decisions made by Sunny's bar and Ms. Marks that night. And if you find that Ms. Marks was more at fault, well, then you cannot find Sunny's bar liable. And today, well, everyone agrees that the cause of Ms. Marks's death was intoxication. Where we disagree is whose fault it was. And so today we're going to ask you to look at Ms. Marks's decisions. Look at the choices she made and ask yourself whether they caused her death. But before we talk about any of those decisions, well, members of the jury, I want to be clear. It is hard. It is hard for us to ask you to look at the actions of a girl who died and ask if that's why she died. But that's what the law requires us to do. And so today, well, we're going to let Ms. Marks speak for herself. We won't ask you to blame her, just to listen to her. We're going to ask you to focus on a statement Ms. Marks made multiple times throughout the night. Before, during, and after her time at the bar, go big or go home. And when you do that, it'll become clear that Ms. Marks was more at fault. She went big, and so she didn't get home. But members of the jury, I won't just ask you to take my word for it. You're going to get to hear from Morgan Levin, Jessica's best friend and the person who was with her that night. And they'll tell you about Jessica's plan to go big. But that even though that was always her intention, she decided to drive. And members of the jury, that wasn't a decision she made after leaving the bar. She made that choice hours earlier, before Sunny's bar had served her a single drink. She went big, and so she didn't get home. And at the end of today's trial, it'll become clear that it was a combination of those choices. The choice to drive and the choice to go big, to drink a lot, that killed her. Choices she made before she ever stepped foot in Sunny's bar. She went big, and so she didn't get home. That's why we ask that's why at the end of today's trial, we'll ask that you find Sunny's bar not liable. Thank you.
Thank you, counsel. Before the plaintiff calls its first witness, I will ask everyone to switch back to gallery view, back up in the top right corner of your screen. And whenever you're ready, counsel, you may call your first witness.
Yes, Your Honor. At this time, the plaintiff calls Ms. Levin to the witness stand. Good afternoon, Ms. Levin.
Good afternoon.
Please state your first and last name, spelling your last for the record.
Hi, my name's Morgan Levin, Levin.
And Ms. Levin, if at any point you can't see or hear me, please do let me know.
Okay.
Now, do you know someone named Jessica Marks?
I do. Jessica was my best friend. We were two peas in a pod. I met her in middle school. We were friends throughout then, up until college, where she was my other half.
Now, were you with Jessica on March 24th of 2019?
I was, yes.
When did you two meet up?
We met around 6. She came to my Airbnb. Well, she came to pick me up to go to her Airbnb. And then we went to Sunny's rooftop bar at around 9.
Now, once at Sunny's, did you or Jessica order anything to drink?
We did. We ordered a lot to drink. But we started with a bottle of wine and some White Claws, some beers and shots.
And who took these orders from you?
It was actually Sunny Mehta, the bar owner, who took our orders.
Now, Ms. Levin, I'd like to turn your attention to a layout of what has been marked for identification as exhibits 11 through 16. Now, what are these?
Well, these are actually pictures I took at the bar. I mean, they were going to be for a Yelp review, but obviously that never happened.
And there are numbers next to each photo. What do those represent?
Those are actually the timestamps of when I took the photos. My phone automatically gives you the timestamps of them.
And does this diagram fairly and accurately depict the table as you saw it throughout the night?
Yes.
The plaintiff moves exhibits 11 through 16 into evidence.
Objection?
Without objection, no objection, Your Honor, and we agree those timestamps have been stipulated too, so we have no issue with those.
All right, so received.
And at this time, we ask that these exhibits be published for the jury.
Also without objection, Your Honor.
All right, you may proceed.
Now, Ms. Levin, over what span of time were these photos taken?
From the beginning to the end of the night, when we first got there to when we were about to leave.
And did you and Jessica finish all the drinks pictured here?
Well, I don't exactly remember if we drank every last drop of them, but I do know Jessica had more to drink than I did.
And how much of what's seen in these photos did you drink?
Well, I had a glass of wine and one of the beers in the photos.
Is there anything not pictured in these photos that Jessica had?
Yeah, we both ended the night. We got a green tea special shot. That's what we both had.
What's a green tea shot?
Well, it's there's whiskey and peach schnapps, probably some other stuff in it, but it was okay.
And when were you served this green tea shot?
It was the last drink we got at the end of the night, so it was sometime before 11:40.
And Miss Levin, how tall was Jessica?
She was really short. We always made jokes about it, but she's only 5 foot tall.
And how much do you think she could have weighed?
Maybe a little more than 100 pounds.
Now, did these drinks that Jessica had have any visible effect on her?
Definitely. When we came in, she was a little buzzed, but she just got drunker and drunker throughout the night. You could see it and even smell it on her.
Now, I'd like to show you a video of Jessica that night, Exhibit 10. I'm not able to hear the sound of the video.
I'm having the same issue, Your Honor.
Yes. Yeah, no, I can't hear this. The sound's not coming through on the video.
And at this time, I ask that time be stopped while this issue is sorted out.
Absolutely, no problem.
And Your Honor, we'd be happy to go ahead and screen share that exhibit for counsel, if that's easier, just for the court's ease.
All right, yeah. I mean, if you don't mind taking orders about when to stop and start it, then yeah. I mean, if y'all can be agreeable with it, go
Hi,
ahead.
everyone.
It appears.
Well, it looks like they've got it under control, so I think we're all good there.
Yes, Your Honor. If Ms. Ailsutter could please play the video.
Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Levin, what is this?
I actually had filmed that video of Jessica.
And what time did you film that video?
I posted it at 11:11 that night, so sometime before then.
And is it a fair and accurate representation of that video you filmed?
Yes, it is.
The plaintiff moves Exhibit 10 into evidence, Your Honor.
Without objection.
So received.
And at this time, we ask that Exhibit 10 be published for the jury.
You may, and feel free to publish to the jury anything that's been admitted into evidence for the remainder of trial.
Yes, Your Honor. Now, Ms. Levin, have you seen Jessica drunk before?
I have actually. It started a few years prior in high school.
And how would you describe her behavior in this video you just watched?
Well, she's definitely drunk in that video.
Now, did she interact with Sunny after this video was taken?
Well, yeah. Since I posted it at 11:11 and it was taken before then, Sunny came by after that video was filmed before we ended out the night with shots.
Now, did you and Jessica, interact with Sunny at any other time that night?
Well, yeah. I mean, Sunny had to come by the table to take our order and bring it back. So 8 or 10 times.
After those interactions, did Sunny make any comments suggesting that he didn't want Jessica driving?
He did actually. He looked one time. He came to our table and looked at Jessica and said, "I hope this one's not driving."
Was there any instance of Jessica stumbling or falling?
Yeah. We were walking down the stairs together and she nearly face planted on the ground. She stumbled into Sunny, caught her, and said to Frankfurt, the bartender, "We might need to cut this one off."
Now, Miss Levin, when did you two leave that night?
Sometime after 11:40.
Did Jessica drive herself?
Yeah, she tried to.
Did you get in the car with her?
No,
Why not?
she just seemed really drunk. I didn't feel safe getting in the car with her, so I got an Uber.
And Miss Levin, what happened once you left the parking lot?
My Uber followed behind her, and I saw her car veer into traffic and off the highway.
Sorry, Miss Levin, but nothing further at this time, Your Honor.
Cross-examination.
Yes, Your Honor. Ms. Levin, I want to start off by talking about some decisions Ms. Marks made before you even got to Sunny's bar. Now, before you got to that bar, you went over to her Airbnb, isn't that correct?
Yes,
Jessica made an Instagram post while you were there?
she did.
Your Honor, we'll be displaying Exhibit 5 rather, constructively outside the view of the jury. Ma'am, you recognize this as the Instagram post Ms. Marks made before you left for the bar?
I do.
That looks to be fair and accurate.
It does, yeah.
We offer Exhibit 5 into evidence.
Any objection?
No objection, Your Honor.
So received.
Ms. Levin, if you look at that caption, well, Jessica says, "Go big or go home." Isn't that right?
Yeah, it's in the hashtag. It's something she liked to say.
Oh, she also posted something onto Twitter, didn't she?
Yes, she did. It was a video.
Your Honor, we'll be displaying Exhibit 6 constructively outside the view of the jury. Ma'am, this is the video you were talking about?
Yeah,
You were there when it was filmed?
I was.
It looks to be a fair and accurate copy of that video?
Yeah.
Your Honor, at this point, we offer Exhibit 6 into evidence.
Any objection?
No objection to Exhibit 6, Your Honor.
So received.
Mr. Marks, could we go ahead and press play?
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Ms. Levin, Ms. Marks was already saying go big and go hard before you even got to Sunny's bar. Isn't that right?
Oh, well, yeah, she did say go hard or go home in the video. You know, it's something she liked to say. I guess you could call it her motto.
Ma'am, you're saying go hard or go home was her motto?
It's something she said.
Okay, well, I want to talk about another plan that Jessica made that night. Now, when you left the Airbnb to go to that bar, she didn't call an Uber, did she?
No, she drove.
Exactly. Even after saying go hard or go home, she decided to drive.
Yeah, she did.
Well, I want to talk about that drive. Now, to get from the bar to the Airbnb, it didn't take 5 minutes.
No, it was around 30 minutes to get there.
Exactly. It took almost half an hour.
Right.
But Jessica decided to make that drive in one of the biggest cities in the world.
I guess it is one of the biggest cities in the world.
A city she'd never been to before.
Well, I'm not actually sure if she went to it or not before.
Ma'am, you said that this trip was her first time visiting California.
I didn't. But it probably was.
Well, ma'am, in your deposition, you said that this was her first time being to California. Is that correct?
So, yeah.
Right. You'd agree that she decided to make this drive in a car that wasn't her own.
That's right. It was a rental car.
She decided to do all of this at night.
Right.
So, ma'am, just to be clear, she decided in order to get home that night, she would have had to drive for 30 minutes in a city she'd never been to before in a car that wasn't her own at night.
Yeah, that's right. She would have known she would have known the route back.
But ma'am, after leaving the bar, well, she would have had to do that after drinking for hours.
Right.
Well, ma'am, I know this might be difficult, but I want to talk about what happened when you left the bar. Now, like you said on direct examination, you didn't feel comfortable getting in a car with Ms. Marks.
No, she had definitely drinking too much from what I had seen.
But ma'am, even though the Uber was right there, well, she decided to get in her own car.
Yeah, I don't know why she would have done that. I offered the Uber to her and she just insisted on getting in her own car.
Exactly, ma'am. She insisted. And she said, I've gotten pretty good at driving after a big night. Isn't that correct?
Yeah, I don't know what she meant by that, but she said it.
Thank you, ma'am. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. May this witness be excused?
She may. And does the
And
plaintiff
at
rest?
this time, yes, Your Honor.
All right, defense, whenever you're ready.
Yes, Your Honor. At this time, defense calls Sunny Mehta to the stand. May I proceed? Thank you. Good afternoon. Could you go ahead and introduce yourself to the members of the jury?
Sure. Good afternoon, members of the jury. My name is Sonny Mehta, and I'm currently 27 years old. I own a business in Southern California.
Well, sir, you mentioned that you own a business in Southern California. What exactly do you do for a living?
Well, it was always my dream, I guess you could say my American dream, to own a business in the United States. So I opened a bar in Malibu. It's prime real estate.
Oh, Mr. Mehta, what was that bar called?
I named it Sunny's Rooftop Bar.
Do you know why you're here today?
I do. On the night of March 24th, 2019, there was a girl at my bar. Her name was Jessica. She had a few drinks and she drove away. She died last night, unfortunately.
Oh, sir, we'll talk about that night in just a moment. But first, I want to talk about some of your responsibilities as a bar owner. Do you have any training that helps you determine whether customers are intoxicated?
Of course I do. I took several educational courses on how alcohol might affect the human body. Several, like I said, all of these are required in order for me to own my business.
And during those several training courses, well, what symptoms are you taught to look for?
Well, there's a long list. I had to memorize all of them, but a big one would be losing their footing. They're falling over. They smell like alcohol. Their eyes are bloodshot. Those are just a few I can think of off the top of my head.
Well, we'll talk about how those symptoms may have applied to Ms. Marks. But first, I want to take a step back. When did you first meet Ms. Marks?
I mean, I only met her one time. It was the day she was at my bar. She got there around 9 o'clock on March 24th.
And sir, while she was there, did she order any drinks?
She did. She wasn't the person who was paying for them, but her friend was ordering them. They ordered a few rounds.
Do you know who was serving her that night?
Well, it was me. I like to run the front end and I like to interact with all of my customers, so I brought them everything they ordered.
Okay, well, I want to talk about what they ordered. Your Honor, we'll be displaying Exhibit 17 constructively outside the view of the jury. Sir, do you recognize this document?
I do. It's how you say in English, a receipt. It's the receipt of Morgan Levin from the night of March 24th.
And does it look to be an accurate copy of her receipt?
It looks like it. I remember that they purchased those drinks.
Well, Mr. Mehta, just to be clear, did you regularly print out receipts like this one at Sonny's bar?
Yeah, of course I did. Every transaction had a receipt.
Could you tell the members of the jury what that process looked like?
Well, I have a computer inside. Someone would put in an order. I would go up to the computer, type it in, put the cash, and it would print a receipt. Every transaction came with a receipt, like I said.
Your Honor, at this point, we offer Exhibit 17 into evidence.
Any objections?
No objection to 17, Your Honor.
All right, so received.
Yes, Your Honor. Mr. Mehta, do you know which of the drinks on this receipt were for Ms. Marks?
Of course not. I mean, I had several customers that night. I was running everywhere, so I wasn't watching to see what Jessica Marks was consuming. I was too busy.
Well, based on your experience, can you tell how intoxicated someone is solely based on the amount of alcohol they've consumed?
Based off the courses I took, I learned that a lot more goes into how intoxicated someone may be other than what they've drinking. It could be genetics, it could be their height, their weight. There's a lot of things to consider.
Well, sir, what do you look for then in order to tell if a customer is drunk?
Like I said before, there's a lot of symptoms, but the biggest one to me is losing balance, throwing up, passing out. They look very sleepy, things that indicate they're not exactly, completely awake. That's when you know they're really drunk.
Well, sir, let's talk about some of those signs. Do you know about how many times you interacted with Ms. Marks that night?
I would say around a half dozen times.
During any of those interactions, did you see any signs that Ms. Marks was intoxicated?
Not once. She was the one who looked okay. Her friend was the one who looked, like she'd had a little too much to drink.
Oh, sir, during opening statements, Ms. Cho kept saying you saw and you kept serving. Did you ever see those symptoms we talked about?
I didn't see anything. Like I said, Jessica Marks, okay, she looked fine.
Oh, just a few moments ago, Ms. Levin told us about an incident on the stairs at your bar. Just to be clear, did that incident ever happen?
No, when I heard that, I couldn't believe it. Jessica never at one point fell into me. If she did, I would have cut her off immediately.
Well, sir, we've talked about some things you were aware of. I want to talk about some plans you may not have known about. Your Honor, we'll be displaying Exhibit 6. It's already in evidence. Sir, have you seen this video before?
I did. I had an interview with attorneys before today's trial, and they showed me this video.
So did you hear Ms. Marks say, go hard or go home, not ready to go home?
At the bar, no. Like I said, she seemed sober, quite honestly. There was nothing to tell me she was intoxicated.
So were you at all concerned about how much she'd had to drink?
Well, I didn't even see all the drinks she had. Like I said, I was busy. So I would say no, she seemed fine. I wasn't concerned.
Well, sir, in the past, have you been concerned about how much a customer has had to drink?
Absolutely. I hate to sound insensitive, but I guess Americans drink for another reason besides the taste. In other words, yes, I've had to stop many people from drinking at my bar.
And in those cases, well, what exactly would you do?
I would take their keys, I would call them a cab, I would stop them from drinking, all the things like that.
Sir, on March 24th of 2019, did you feel the need to do any of that for Ms. Marks?
No, like I said, she looked okay. I actually asked her if she was the one to drive home because I was very worried about Morgan Levin. She looked, like I said, intoxicated.
Thank you, sir. Nothing further, Your Honor.
Cross-examination, Your Honor.
You may proceed.
Good afternoon, Mr. Mehta.
Good afternoon.
My name is Sophia Cho, and I'll be asking some questions on the behalf of the plaintiff. If at any point you can't see or hear me, please let me know.
Of course.
You were working at your bar on March 24th of 2019,
That's correct, I was.
and Jessica Marks first arrived at around 9 o'clock.
Yes, she was with her friend, Morgan Levin.
And you interacted with Miss Marks several times over the course of that evening.
Yes, around a half dozen times. I would say maybe a little bit closer to 10, but that sounds correct.
You served alcohol to her that night.
I did, yes.
At no point did you refuse to serve her alcohol.
No, it did not look like she had to be cut off to me.
Now, you're aware of the legal requirements to serve, correct?
I do. I've taken an extensive amount of courses mandated by the state.
Right, and you have training on recognizing when someone is obviously intoxicated.
I do, that's correct.
And you know that if a minor is obviously intoxicated, you are required by law to stop serving them.
Well, if someone was a minor, I wouldn't serve them in the first place. But when somebody is obviously intoxicated, yes, I immediately stop serving them.
And all your employees are trained on this as well.
Yes, they are. I make sure of it.
And Frankfurt Johnson was trained on this.
Yes, absolutely.
Now, I'd like to turn your attention to what has been marked for identification as Exhibit 3. This is Morgan Levin's ID.
It looks like Jessica in the photo. I don't think that's what Morgan looked like, no.
Excuse me, Jessica Marks's fake ID?
I mean, I guess it's her ID. It's just her on the picture, but I don't recognize the ID itself.
So you're saying you've never seen this ID before?
When she came into my bar, she showed me an ID, but I can't exactly remember if it's this one.
You're saying you don't remember if this is the ID that Jessica Marks showed you on that night?
I mean, it's entirely possible. I checked an ID. She handed me one, but I can't remember exactly if it's this specific ID. It doesn't seem familiar to me.
Now, you can take that down, Ms. Ailstadter. Now, Mr. Mehta, in terms of training, you and your employees are trained to look for slurred speech,
Yes, we are.
uncoordinated movement,
Yes, that is a sign of intoxication.
loud behavior.
When you say loud, you mean like they're speaking loud?
Yes, speaking loud.
Yes, we're trained to look for that as well.
And as you said, these are all obvious signs of intoxication.
I would say there are signs of intoxication, but depending on how extreme, obvious intoxication, possibly.
And Mr. Mehta, intoxication can affect judgment, correct?
Absolutely.
Now, I'd like to talk about what Ms. Marks was served that night. I'd like to turn your attention to what has been marked for identification as Exhibit 17.
Okay.
And this is a receipt of their orders.
Yes, it is. I saw this when the other lady was questioning me.
Right, you served them many of these drinks.
I served them all of these drinks, to my knowledge.
And right down there at the bottom, you served Morgan and Jessica a green tea shot.
That's correct. They split them.
And this was toward the end of the night.
I couldn't give you an exact time, but yes, it was towards closing time.
And a green tea shot is a mix between whiskey and schnapps, correct?
That's correct. It's one of my favorite drinks, actually.
And both of these are alcoholic beverages.
Yes, they are.
Now, Mr. Mehta, what is the legal BAC limit for a girl of Jessica Marks's age?
Oh, for somebody who is under 21, it is 0.01.
Your Honor, at this time, we ask that Exhibit 22, which has been pre-admitted, be published for the jury.
You may.
And at this time, no further questions, Your Honor.
Anything further from
No
Mr. Mehta?
redirect, Your Honor. At this point, the defense rests our case in chief.
All right, and before we rest the completely closed evidence and head to closing arguments, I did just want to clarify one thing for the record.
Of course.
Did counsel for either side intend to admit Exhibit 3? I know there were some questions asked about Exhibit 3, the fake, allegedly or purportedly fake ID. Did you intend to move that into evidence from either side? Would you like it for closing arguments?
Your Honor, defense won't be using that. We do ask, however, that if counsel for plaintiff is going to use that in closing arguments, they move to admit it now.
That's what I'm asking.
No, Your Honor, we'll be not using it in closing arguments.
All right, then we can proceed to closing arguments. Everyone should please switch back to speaker view. And also, since both witnesses are, I'm sorry?
Before proceeding, Your Honor, may I please have a 5-minute recess?
Counsel, are you amenable with that?
Your Honor, we're fine with that. I don't believe the rules indicate any recess before closing, but if counsel would like one, we're absolutely fine with that.
Why don't we take, then let's do 3 minutes. Is that all right? 48 after
Yes,
the hour. I'll see you back.
Perfect,
for
Your
closing.
Honor.
All right.
Sounds good.
All right, everyone should switch back to speaker view, and counsel, whenever you're ready, you can begin with closing arguments.
They saw and they kept serving. It was March 24th, 2019 at 11:58 p.m. when Jessica Marks, a college student at Drexel University, drove off the Pacific Coast Highway after a long night of drinking. Just 17 minutes earlier at 11:41 p.m. in Sunny's rooftop bar, Morgan Levin closed her tab for a bottle of wine, 2 beers, 3 hard seltzers, and green tea shots, all of which she and Jessica shared over the course of the night. But Morgan only had a beer, a glass of wine, and 1 shot. The rest, consumed by a petite 5-foot Jessica. Those drinks that killed Jessica had been served to her by Sonny Mehta and Frankfurt Johnson. As Morgan Levin said, Jessica kept getting drunker and drunker because they saw and they kept serving. For that reason, we charged the defendant with serving alcohol to an obviously intoxicated minor, a duty placed on them by the Dram Shop Act. In order to meet our burden, we had to prove by a preponderance of the evidence 3 things. 1, that Jessica was underage. 2, that Sonny's overserved alcohol to Jessica. And 3, that her intoxication was a substantial factor in her death. As for the first element, you saw Jessica's fake ID in court today. In fact, it's stipulated that Jessica was underage. The defense concedes that fact. But I'd also like to remind you that it's not necessary we prove the defendant knew she was a minor. All that matters is that she was. As for the second element, we must prove that a reasonable person in the defendant's position should have viewed Jessica as obviously intoxicated and continued to serve her. Morgan Levin told you of Jessica's fall. It's easy to deny, like Sonny did today, but why would Morgan lie? Ladies and gentlemen, we learned that it was Sonny that Jessica fell on. And it's then that he says, "Whoa, Frankfurt, we may need to cut this one off." That's knowledge, that's awareness, but he never did cut her off. And ladies and gentlemen, I want to remind you of something that happened today on the cross-examination of Sonny. He told you of how intoxication can manifest itself. Loudness, slurring of words, incoordination. Now remember that video of Jessica. Remember her behavior, and then the symptoms Sonny described to you. He's told you time and time again that he just didn't see. But it doesn't matter what he saw. It matters what a reasonable person should have seen. Remember that video that was 37 seconds long. And you are all reasonable people, members of the jury, like the standard requires. I can guess that it took you even less to determine her state. Maybe 5 seconds. And now I want you to think of Sonny Mehta, a trained professional who is required to know how to spot intoxication. If you can spot Jessica's intoxication, he has to spot it. It's his duty to spot it. And the actions he failed to take once spotting it is what caused her death. So we've proven he should have seen. But it's moments after when Sonny gives Jessica a green tea shot composed of whiskey and schnapps, both of which are alcoholic beverages. That final act breaks the law of the Dram Shop Act, and there's no dispute as to the third element, that the alcohol Jessica ingested is what killed her. Ladies and gentlemen, the defense has told you time and time again about the choices Jessica made. But you heard today that alcohol can impair judgment. It's the alcohol served to her by Sonny's that stripped her of her judgment. Just like how he should have seen. He should have taken her keys, should have called her an Uber. That was his duty. But he didn't. Because he saw and kept serving. Because of that, we ask that you hold the defendant liable. Thank you.
Thank you, counsel. Closing arguments from the defense.
Yes, Your Honor. Members of the jury, I want to take you back to an important moment in today's trial. On my cross-examination, I asked Ms. Levin about a statement you heard Ms. Marks made multiple times. go big or go home. Her response? She said it all the time. It was like her motto. Ladies and gentlemen, we heard time and time again that she was so determined to go big. And she was so determined to drive. And that cocktail is deadlier than anything the bar could have served her. She went big. And so she didn't get home. And we'll talk some more about her decisions in a moment. But first, I want to focus on the plaintiff's burden. Because when they brought a claim of wrongful death, well, they took on the burden to prove two things by a preponderance of the evidence, simply meaning more likely than not. They have to prove that Sonny's bar kept serving Ms. Marks when she was obviously intoxicated, and that as a result, she died. And a moment ago, well, Ms. Cho told you that the standard in today's case is that a reasonable person would have known Jessica was intoxicated. Well, that's not entirely true. Today, they had to prove that a reasonable person would know she was intoxicated based on what the defendant was able to observe. And today, they couldn't meet that burden. Because as much as they wanted you to believe that Mr. Mehta knew about those signs, that he saw the signs and kept on serving, well, that's just not supported by the evidence. First, they showed you this video. And it's true, I mean, she doesn't look completely sober. But Mr. Mehta wasn't sitting at a table with Ms. Marks that night, wasn't carrying out conversations with her. He certainly wasn't present when this video was filmed. Sonny Mehta saw Ms. Marks for maybe 10 seconds, a handful of times that night, just to ask what she wanted to order. And as much as the plaintiff wants you to believe that this is evidence of obvious intoxication, well, let's actually look at it. Her eyes aren't red. She's not stumbling around. Her face isn't flushed. Plaintiff wants you to believe she's slurring her words. She's not. Sure, maybe she's talking a little slow. Maybe she seems happy to be out at a bar. But when you're talking to someone for 10 seconds at a time, only getting a couple of words, well, that's not enough to tell if they're obviously intoxicated. So when she says they saw the signs and kept on serving, well, members of the jury, you can say no. We don't actually know if they saw the signs. And members of the jury, since that was part of their burden today, well, you cannot find Sonny's bar liable. She went big. And so she didn't get home. And if you agree with us, if you think that Sonny's bar didn't serve her when she was obviously intoxicated, well, then that's it. Case closed. But if you disagree, if you think the plaintiff met their burden today, well, that's where we get into something called an affirmative defense. Because today, even if the plaintiff met that burden, if we have met ours too, if we've proved that Ms. Marks was more at fault, then you cannot hold Sonny's bar liable. And like I told you at the beginning of today's trial, it is hard for us to ask you to consider Ms. Marks' choices. It is absolutely a more comforting story to look at the bar, to look at Sonny Mehta and say he should have stopped her. But the law says that's not enough. As difficult as it is, the law requires that we set aside those emotions and evaluate the facts. And so I want to talk about some of the evidence that we heard. Members of the jury, today, you learned about two decisions that Ms. Marks made before she ever stepped foot in Sonny's bar. First, that she planned to go big. I mean, she said it over and over again. She said it in this video, posted it in that Instagram caption, said it again at the bar in this video, and said it as she was leaving. Second, you'll learn that from the outset, she decided to drive. And members of the jury, on their own, there's nothing really wrong with either of those decisions. I mean, it was spring break. It's understandable that Ms. Marks wanted to have a good time. And of course, it's okay to drive a car. But when you mix drinking with driving, well, that's when things get dangerous. She went big. And so she didn't get home. But a moment ago, well, Ms. Cho ignored any questions of fault, ignored all of the decisions Ms. Marks made, and asked you to just focus on obvious intoxication. But that's not enough. They don't win by proving obvious intoxication alone. We also have to decide who was more at fault. And so, as difficult as it is, we have to consider those choices. Because at the end of the day, it wasn't the alcohol that was served that killed her. It was the combination of drinking and driving. It was the fact that she went big. It was the fact that she drove home. But members of the jury, those weren't Sonny Mehta's decisions. That wasn't his motto. They were Ms. Marks's. She went big. And so she didn't get home. That's why we ask that you find Sonny's bar not liable. Thank you.
Thank you, counsel. Any rebuttal from the plaintiff?
Yes, Your Honor. They saw and they kept serving. But just now, the defense told you that the conversations between Jessica and Mr. Mehta, were 10 seconds long. But I want you to remember that they were 30 seconds to a minute. Plenty of time to see the intoxication. That video you saw was 30 seconds long. And I can guess that it took you even less to see her intoxication. 5 seconds, 10 seconds. And remember Sonny Mehta's training that he is required by law to receive. If you're able to see the intoxication, Sonny has to have seen it. And ladies and gentlemen, we've proven to you today that Sonny's was at fault. As for the second choice you have to make, that it was Jessica's fault. Ladies and gentlemen, you heard today that alcohol impairs judgment. That's why Jessica couldn't make reasonable decisions on her own. The defense just told you that when you mix drinking and driving, things get dangerous. But that's why we have the Dram Shop Act. That's why we put the responsibility on the bar. Find the defendant liable. Thank you.